welcome all of you on the session on membership. Now when we talk about membership, let us see, the first thing is to become a member of a society, what one has to do? One has to make an application. Now after you make an application, naturally you will be making an application to the society. Society means managing committee. So once you make an application, the next thing comes, the managing committee has to decide on this. Who is the deciding authority? Managing committee. Now they are given certain time frame. Within time frame they have to decide. Suppose if they don't decide, the next course of, one who is making an application, they have to decide on the membership. When we talk about deciding a membership, that means either there can be three situations where the membership can be decided. One, they can approve the membership, grant the membership, correct? The second possibility is that they may reject the applications. And the third possibility is that they can hold it. When I say hold it means they will not be deciding on the application. So without taking any decisions, they may just hold it without communicating the decisions, without taking the decisions. Is there any other possibility? The answer is no. So when you approve, yes, you will pass a resolution in the managing committee or in the general body as the case may be, and then you do the necessary procedure. Now when you reject the application, naturally any decisions, when you decide any decisions, it has to be speaking order. When I say speaking order, the rejection has to be based on certain reasons. Now the reasons what they are giving, there can be again two types of reasons. One which can be outside the purview of the law. The second one could be within the purview of the law. And third, maybe I can say the one where it is called rejecting, asking them to comply with certain things. Comply the certain things. That means asking them to cure the what you call the reasons for rejection. Just to give an example, if you are applying for a membership, you are required to sign the application form. That is most important. Somebody has made an application without signature. Then they may say, okay, we have rejected your application because there is no signature. So which means you put the signature and send it to us. The other could be that you have made an application, but you are required to submit or attach, let us say, agreement for sale copy in a housing society. Now you have not attached that, and then they will say, okay, your application is rejected because there is no duly stamped or paid registration agreement or registered agreement copy. So which means you cure that. So one, as I said, the reasons could be beyond the provisions of the Act. The second could be the reasons within the purview of the Act that we need to look into. The third could be the certain things where they may ask you to cure the defects in the application. So this is how the rejection can happen, which means rejection has to be in the speaking terms. When we say speaking, that means it has to be with the proper justifiable reasons. Now there are reasons where they may hold it. Now if they are holding the membership for any reasons, in that case there is a time frame. Within that time frame they have to decide. If they don't decide, the law itself provides that's what will be the consequence. The consequence is, naturally the law says it is treated as deemed member. Now as we know, deemed is a legal fiction. Are you with me? Yes. Deemed means it is something which is not happening, but the law provides for deemed. That means deeming, we always call it as a legal fiction. Fiction means a creation of the law, which is created by the law. So therefore, being a legal fiction, the deemed member, once it is a legal fiction, that has to be again confirmed by somebody. See, as we know, there is a deemed conveyance. That means within 4 months of the formation of society, if the conveyance is not written, it is deemed to have been conveyed. That means every society after 4 months, they are deemed having received the conveyance of land and building. But whether they are actually getting that, the answer is no. To get that actually and to authorize or authenticate that, to approve it, we have to go to the competent authority. Same way, here is the situation where a membership is given or application is made to the society and they are not deciding it or they are rejecting. Okay. If these are the two situations where the concerned person may be aggrieved. So even if he is rejected and according to him it is not within the purview of the law and it is not something which they have asked us to comply, naturally, or the compliance which they have asked is something not achievable, then one may get aggrieved of the order of rejection by the society. So therefore they can make a grievances. The grievances is naturally or made to the registrar. That grievances which we are making to the registrar is known as appeal. Now normally we know whenever we make an application to the registrar, it is a registrar where we are making an application. The appeal lies before the higher authority, that is a divisional joint registrar. Then there is something called revision, which is with the cooperative minister. Revision is with the cooperative minister. Then of course writ petition before the High Court and then the special leave petition before the Supreme Court. That is how the hierarchy is there. But here is a situation where we are making application to the society. So therefore the first appeal lies before the deputy registrar or the assistant registrar of our ward. So that is appeal. On the case of rejection, or even if they are holding it, it is deemed to be the member, then because they have not taken a decision, they are supposed to take a decision, they have not taken a decision. So I am deemed to be the member and my membership form or membership application was not decided. So I file an appeal to declare that aggrieved person as the member of the society. That is how it is. Okay. So that is the appeal. That is called first appeal. Then comes the revision. So if there is an appeal, see again I am saying there is an application. After the application there is an appeal. After the appeal there is a revision. Now the application, we understand application is made to the society. Naturally the appeal is made to the deputy registrar and revision is with the joint registrar. Now revision or review. Okay. Review or revision, these are the two important things. Again, it has to be exclusively provided in the respective statute. If it is not provided in the respective statute, that who has the authority to revise, who has the authority to review, then that means the order passed by that authority cannot be reviewed. Try to understand that the application we understand, appeal we understand, but after the appeal, again appeal is also has to be provided in the act, in a specific act. If the appeal is also not provided, revision is not provided, review is not provided, that means it cannot be done. So in that case, that gets decided in the writ petition only. For example, in the case of a deemed conveyance, we know that the competent authority is got a power to decide. But is there an appeal provided in the Maharashtra Ownership Right Act? The answer is no. Is there review provided in the act? No. So that means review and revision or for that matter appeal is not there. Then what we do? We naturally go to the writ petition. We file the writ petition against the order of the competent authority. So that is about the deemed conveyance. Now coming to the cooperative housing society. So there is an application, there is an appeal, there is a revision and then writ petition and special leave petition. So these are the five hierarchy. Now let us go to the provisions of the act. Is there any doubt in this now? Application we are making to the society, the appeal lies with the deputy registrar, a revision or the appeal lies appeal and then of the revision. After the revision there can be second revision, the answer is no. There can be only one revision. The law does not provide for the second revision or second review. Okay. Now, if the application is decided ex parte, that is also there. Sometimes the applications or the appeal is decided ex parte without hearing us. Then the civil procedure code, which we will discuss later, has a provision for restoring the application. So one can say that I was not heard, so I was not given an opportunity. You have decided the appeal or the application or the appeal or revision without hearing me. In that case we can apply for the restoration, and of course whether to restore or not to restore, to set aside the earlier order, not to set aside the order, will be the jurisdiction of the registrar. Now because it is provided in the civil procedure code and law of natural justice is not followed. Law of natural justice means proper opportunity is not given. In that case, he can recall the order. Now there may be a question mark whether when the review, revision and all these powers are not available, can a competent authority recall his own order? Yes, if there are reasonably it is proved that that particular person against whom we have filed the complaint and or the complainant himself was not heard before deciding the appeal or revision or application, then they can ask for restoration and the restoration is also possible. Now you may say, is there any provision made in the MCS Act regarding that or any specific law? The answer is no. It is, we are going with the civil procedure code. Anyhow, now let us get to our provisions in the MCS Act. Now chapter number 3, chapter number 1 is regarding preliminary, chapter number 2 is regarding the registration of a society, amalgamation, all that. We will discuss that later. Now we will come to the membership of the society. Why we have taken up this topic? The membership is the base on which the society is formed. It is the members who come together voluntarily. It is the members who come together voluntarily, form a society, cooperative society, to take care of their common economic interest, and therefore it is a common economic interest, and because of that we call it as a jointly owned enterprise. It is for the economic interest purpose. So coming to the chapter, who can become a member? The first and foremost thing, as I said, an application can be rejected if does not fulfill the conditions for becoming the member. So the condition for becoming a member is given in the section 22. Up to 21 we will not discuss today, but section 22, membership, who may become a member in a cooperative housing society. Naturally, subject to the provisions of section 24, we will see what is that section 24. No person shall be admitted as a member of the society except the following, that is to say, that means subject to the provisions of section 24. If you look at any law, this is the difficult portion in the law. They don't say everything at one place. They will say subject to, save, except, provided. These are certain words which one need to look into. That means subject to the provisions of section 24. That means what is provided in section 24 has to be taken cognizance first, and after taking cognizance of that, subject to that, no person shall be admitted as a member of the society. That means no person shall be admitted as a member. So nobody can be admitted as a member. That is always a negative. Then who can? Except the following. That means only the following persons can be admitted as a members. No other person can be admitted as a member. It starts with the negative covenant. So the moment it starts with no, we say it is a negative covenant. So negative covenant means the terms, so or the provisions. So therefore, subject to provisions of section 24, what is being provided in section 24, subject to that, we will see section 24, no person shall be admitted as a member of the society except one, an individual. Now we don't require any explanation on individual. Any individual can be admitted as a member. Second, who is competent to contract under the Indian Contract Act 1872. That means now we have come across another law which is connected in the MCS Act. That means now we will have to look into Indian Contract Act. Who is competent to contract? Naturally a person who is major. So if a person who is a major, he is the one who is competent to contract. Okay. If he is competent to contract, that means he can be admitted as a member. So can a minor be admitted as a member of the society? Right now it says no, but later on we will see, yes, even the minor can be admitted to the member of the society through the guardian. Because at the end of the day, minor and the mentally challenged persons or unsound mind persons, they also requires to become a member of the society. In that case, there will be a guardian. Now the guardian, there can be a natural guardian, there can be a court appointed guardian. So that is another law. Who can be a guardian, how can be guardianship can be taken, all those is, there is a separate law called guardian law that we will not discuss today. So Indian Contract Act also we know it is one of the oldest act which establishes who can who can enter into contract or who is competent to contract. Second, it also says a firm. What is mean by firm? Firm means a firm, naturally a partnership firm. Here the firm is partnership firm, and for partnership we have Partnership Act 1932. So there is a Partnership Act 1932 is. Then the company means company which is registered under the Companies Act 2013. So that means we have company, because these are the companies, nothing but we call it as a artificial person. There is a difference between an artificial person and the natural person. This is a natural person, this is an artificial person. The artificial person is created by the law. Okay. Now the artificial person also is represented through the natural person by way of a resolution. Then we get any other body corporate constituted under any law for the time being in force. Why they have said any other body corporate? Because there may be new law. Now we have Limited Partnership Act LLP 2008. So Limited Partnership Act, that is other body corporate constituted under any law for the time being in force. It's society registered under Society Registration Act 1860. There is Society Registration Act also. So under that an association of persons can be registered, and that is under the Society Registration Act. They also can become a member. Now a society registered or deemed to be registered under this act. That means a society which is registered under 1860 or a society which is deemed to be registered under 1860. The state government or the central government, that means even the state government can also become a member of the society. The state government also can own the flat plot land. State government themselves as a government of Maharashtra, central government as a government of India in the name of collector or the president or the governor. And there can be a statutory body, that is any other corporate body, that is MADA. MADA is not a state government. MADA is a Maharashtra Housing and Area Development Authority. So that is a separate authority created under the separate law. That is why it is called corporate body under any other law. So LLP is one, MADA is another thing, MMRD is another thing, SIDCO is another thing. They are not government. They are government promoted organizations under a special act passed by the legislation. So the particular company can be created under the Companies Act or LLP or a partnership, or it can be created by act of parliament, it can be created by act of assembly. So MADA is the creation under the act of assembly. SRA is a authority created under the act of assembly, whereas the, let us say, Institute of Chartered Accountant of India is an authority or the body created under the act of parliament. Company secretary is the authority or the act, body created under the act of parliament. So the Reserve Bank is also an authority. Reserve Bank is not a government. Reserve Bank is created under the act of Reserve Bank of India Act 1934 by act of parliament. So these are the, that is why any authority, that is why it is said, just go back, that is why it is said any other body corporate constituted under any law for the time being in force. Similarly, we have public trust registered under any law for the time being in force, because there is a public trust also. We have every state, Maharashtra, we have Maharashtra Public Trust Act 1950. So a public trust registered under the law for the time being in force, provided that provisions of clause A shall not apply to an individual seeking admission to a society exclusively for the benefit of students or school or college. That means now the moment we say any law is there, any section is there, when I read these sections, the most important thing is you have to go through, is there any proviso? What do you mean by proviso? Can anyone tell me? Proviso means something? Condition, no?
Exception.
Proviso means always an exception, which is not generally, what is said is generally. Proviso means, proviso means exception. So exceptions, every act, every rule, everything has certain exceptions. This is exception. So what is the exception? Why? It said an individual who is competent to contract can become a member of the society. However, there is an exception provided. What is that? This is a general law. But what is the exception? Provided means always exception. What is that exception? Exception is that in case of a school, college, where there is a, let us say, canteen, there is a bookstall which is run by a cooperative society run by the students. Students will become a member. Their age may be 15 years, 16 years, 12 years, 13 years. So this is a canteen for the benefit of the students, or a hostel, or at least let us say bookstall, which is created for the benefit of the students. That means students become the member there, and therefore for them the age limit is not applicable. Is it clear? Yes. Now next. So this is how provided further. Now whenever you see the proviso 1 is provided, proviso 2 is a second exception. So whenever it is a second exception, provided further, the word used is provided further. So that means this is a second exception. See, the law could have been made very simple, crystal clear. However, they want to make like this only, provided further that subject to the terms and conditions as may be laid down by the state government by general or special order. Now the question arises, whenever a government wants to come out with any GR, that is called government resolution, or a government order, they call it as GO, either government order or a GR, special resolution. Now this can be for whenever they are issuing, they have to issue by exercising the powers given to them under a certain sections of the act. Without having power under a particular sections of the act, they cannot come out. So therefore, now here it says further, provided further that the subject to such terms and conditions as may be laid down by the state government by general or special order, a firm company may be admitted as a member only of the society which is federal or urban society, or which conducts or intends to conduct an industrial undertaking. Which means provided further that subject to, that means government can come out with the special or general order. Try to understand, they can come out with the general or special order and putting certain terms and condition in that, a firm or a company may be admitted as a member of the society which is a federal or urban society. Which is a federal society. See, whenever the word comes, federal, what is federal? Again, you have to go to the definition given in the section 2 of the act. So, urban society, that means the society which is registered in the urban area, which conducts or intend to conduct an industrial undertaking, which conducts or intend to conduct an industrial undertaking. Industrial undertaking means again, so in this case of societies, there a firm or a company may be admitted for which there can be certain conditions. Now, in the case of a co-operating society, there was a condition or the order passed by the government that in a housing society, if somebody wants to become a member, a company wants to become a member, then of course it should not be more than 50%. A membership, more than 50% of the members in a co-operating society cannot be a company. That is what exactly has been made in that special order. That we will see later. But what I am saying is, provided further that subject to such terms and conditions, a firm or a company may be admitted as a member of the society which is federal. So there may be certain conditions. So this firm or a company can become a member in a federal society. Now there is a difference between a primary society and a federal society. Are you aware of that? which means in a primary society there can be members who are called first layer. So in a society there are more layers, but let me come to only two layers now. Say there is one which is known as the primary society. In the primary society we all become a member. So I am just giving you only two layers. One is a primary society. So in a primary society, who can become member? Individual, then firm, company, any corporate body, state government, they are primary members. So here individuals are the members. Now these primary societies who become a member and create one more society which is known as a federal society. In a case of a federal society, the members will be only society. Are you with me? That means in a federal society, a primary society can become a member. Can an individual become a member in the federal society? The answer is no. Federal, the word itself says it is the society consisting of the societies. Now, however, further provided that the state government may provide an order saying that a firm or a company which is supposed to become member of only primary society and thereafter the primary society should become member of the federal society, here the exception is provided that firm or a company can be made member directly to the federal society. Are you with me? So that means they need not be a member in the primary society, they can straight away become member of the federal society. I will give you one example, maybe it is interesting for you. Let us say there is a sugar, because federal society again for each objectives there can be federal society, for there can be area wise there can be federal society. Now I will just take you a case of sugar factories. Okay. In the case of sugar factories, all the sugar factories or sugar cooperatives, they are the primary societies. Now sugar cooperative societies can become a member in the sugar factories federal society. Now there can be exception that sugar factory which is run by a company, which is run under the Companies Act, where there are shareholders in that company, they may be allowed to become a member in the federal society of a cooperative sugar. Are you with me? Yes. So this is how the exception can happen. So we are talking about further that such terms and conditions laid down by the state government, by general or special, or a firm or a company may be admitted as a member of a only society which is a federal or urban society which conducts or intends to conduct a industrial undertaking. Sugar factories is industrial undertaking, your what you call weaving mills, so certain marketing federation they are allowing. Now we saw provided, then we saw provided further, now third provision, provided also. They could have written 1, 2, 3, but no, they are giving exception. Provided also. That means now the third exception. What is the third exception? Provide also that any firm or a company which is immediately before the commencement of this act. The commencement of this act means commencement of the MCS Act. That is 1961. Commencement of a member of a society deemed to be registered under this act shall have, subject to other provisions of this act, the right to continue to be such member on and after such commencement. Now what it says? Now what happens? Prior to MCS Act, there was another act. What was that act?
1930 Society Act.
Bombay Co-operative Societies Act. At that time, Gujarat and Maharashtra was called as a Bombay provincial. That means Bombay state. So at that time it was Bombay. So at that time Bombay Co-operative Society Act 1925. It is not 1925. So there was act called Bombay Co-operative Society Act 1925. Now we know there is a Companies Act 1956. Thereafter Companies Act 2013 has come. Now the society which are registered or companies which are registered under 1956, they are still continuing. So there is a provision always made that the society, companies which are registered under the Companies Act or earlier to that, whatever the act, they are deemed to have been registered under Companies Act 2013. So deeming provision comes, which means, that means a legal fiction is created. So even though it is registered under Companies Act 1956, we say duly registered under Companies Act 2013, because many times when we do a documentation, we write the, let us say, this Swagat Housing Finance Company Limited, which was registered under the Companies Act 1956. But today is the 1956 in live? The answer is no. Though it is registered in the year 1996 under the Companies Act 1956, today if I am making any document, I need to write Swagat Housing Finance Company Limited, a company duly registered under Companies Act 2013, because that is in operation, because that those companies are deemed to have been registered under the Companies Act 2013, and now the law applicable is Companies Act 2013 and not 1956. Are you clear? So that is why whenever we are making a document, you need to look at what is the law prevailing. Even if the society is registered under the Bombay Co-operative Society 1925, and when the law came in Maharashtra Co.Op. in 1961 or 1960, that is the rules 1961, naturally they are deemed to have been registered under the 1960 Act, which you will see in the registration section. Anyhow, so here is the situation, provided also that any foreign company which is immediately before the commencement of this Act, a member of the society deemed to be registered under this Act shall have, subject to other provisions of this Act, the right to continue to be such member on and after such commencement. That means if somebody is admitted as a member prior to the commencement of this Act, on the same terms and conditions it continues. Okay. Now, again, in the law, when you look at the, we have seen the general provisions, then we have seen the provisos. Now, in addition to the proviso, sometimes the law also gives the explanation as a clarification. Now, for the purpose of this section, now you will see for different sections this type of explanation is also given for a better clarity. So, for the purpose of this section, an urban society means, because urban society was not defined anywhere, even if they are defined, of course it is not defined. So, what is urban society? Federal society is defined, urban society was not defined. So, for the purpose of this section, an urban society means the society, the business of which mainly falls within the limits of municipal corporation, municipality, cantonment or notified area committee. That means one need not say that if the society which is registered in a village area where there is no municipal corporation, they cannot be called as a urban society. Urban society means society which is registered in the area of municipal corporation or municipality cantonment or notified area committee. Now, what is notified area committee? Of course, we will have to look into the structure of the local authority. There is something called Local Authority Act. So, we are not getting into further on this, but only thing is it is urban. Now, notwithstanding, now see, now notwithstanding, again negative covenant, okay, this is further exception. Section 1, okay, that is section 22 subsection 1, we have seen who can be made a member of the society and what are the 3 exceptions, and we have seen the explanation. Now, this is an amendment which was done. We will see the year in which amendment is done. As I said last time, whenever there is a section to which or subsection A comes, 1-A means it is a more of an amendment, 1A, 1B and all that. So, this is further explanation has been given. Notwithstanding anything contained in subsection 1, what has been said, notwithstanding whatever is mentioned there, just ignore. Now, you have to ignore this. Notwithstanding anything contained over there, the state government may, having regard to the fact that the interest of any person or class of persons conflicts or likely to conflict with the objects of any society or a class of persons conflict or likely to conflict with the objects of any society or a class of society by general or special order published in the official gazette declare that any person or class of persons engaged in or carrying on any profession, business or employment shall be disqualified from being admitted or for continuing as a member or shall be eligible for a membership only to the limited extent of any specified society or a class of society so long as such person or persons are engaged in or carrying on that profession, business or employment as the case may be, and the question whether a person is or is not so engaged in or carrying on any profession, business or employment, or whether a person belongs or does not belong to such class of persons as declared under this subsection and as or as not incurred a disqualification under this subsection shall be decided by the registrar under section 11. That is under section 11. Now 1b, I will not go to 1b, now let us go to 1a. Now whatever exceptions are made, whatever the general law is made, in spite of that, now in a membership section, again the government has been given the power. Okay. Now government can come out with a special order, general order with reference by exercising power under section 22 subsection 1a, saying so who can be a member of the society, who cannot be a member of the society. Why? Because that particular or a class of persons are going to have something called conflict of interest. Now let us understand what is this mean. Now what happens? Cooperative society, this is again I am coming to the basic thing of a cooperative society. Now what is cooperative society? So cooperative society is a jointly owned enterprise that I have said. It is a voluntary organization. What is this? This is a voluntary organization. What is voluntary? We will see little later. That means willingly. Correct. Now let us come to the thing. Cooperative society is consisting of members. Correct. 1, 2, 3 like this minimum, let us say 10 members. Their members are required. Now who are these members? These are the members who join voluntarily to pursue one economic objectives. What do you mean by economic objectives? Economic objectives means, what do you mean by economic objective? Economic objective means business. To carry out the transaction, to carry out the business. Now, cooperative societies are registered to carry out business activity. Okay. Now that they are registered to carry out the business activity, now the question arises, most importantly, why they are joining the society? To carry out the business activity. Let us say the business activity, I am just giving an example, let us say credit society. Okay. What is the objectives of the credit society? To receive the deposit and to give the loan to the members. Now, if I am becoming a member of a credit society to pursue the business of lending and to accept the deposit, the question arises, can I do as a member? Let us say I am RS Prabhu. Now RS Prabhu is becoming a member of a credit society. Now what is the purpose of joining a credit society? To promote the credit society, to pursue the business of credit society in particular area of operation. Now having joined a credit society, can I do a competitive business of, let us say, money lending in the same area? So I am taking a money lending license and I become a money lender. I am giving money to the people who are staying in my own area of operation. Can I then continue to be a member of a credit society? The answer is no. Why? Because now the conflicting interest, or I am doing a finance company. I am promoting a finance company. I become a shareholder in a finance company and I run that finance company in the same area, because the finance company also accept deposit, let us assume, and also lending, okay, giving loans. Then when I am becoming a member in a finance company, can I become a member in the credit society? The answer is no. Why? Because there is a conflict of interest. I may take a certain information and I can start conflict. Okay, there can be conflict of interest. Similarly, just to give you for some more examples, there can be a cooperative society, let us say that is called marketing cooperative society. when we talk about marketing of, let us assume, the fertilizers. They take the fertilizers from the state government or central government or at a lower rate or from the fertilizer manufacturer, and they market it in a particular area. That is fertilizer, let us say seeds, which is required for agriculture purpose. They give all this to the farmers. Now I become a member in that society because that is the objective, is to get the material at a lower price. Now I will also do some trading activity of fertilizer in the same area. Now what I may do, as a member I will purchase at a lower price, and I may go in this trading company and I may sell it in the higher price. And by doing this I am creating a shortage for my members, and I am taking here, and by taking here I am selling in my personal capacity. I am going to earn the profit. I will come to know that this marketing has only so much limited stock. So this way there can be conflict. Are you with me now? So if this type of conflicts are there, the government may come out with the order saying that government may having a regard to the fact that the interest of any person or class of persons conflicts. A person or a class of persons conflicts or likely to conflict with the objects of any society or a class of society. I have just given a class, any society or class of society, by general or a special order. They can come out with a special order, they can come out with the general order, publish in the official gazette, declare that any person or persons engaged in carrying on so and so business, okay, or any profession, business or employment shall be disqualified from being admitted. So such persons will be disqualified. Let us say, for example, in a marketing society, a special order may come out with the government. In a marketing society, the person who is doing trading of similar items cannot become a member, because this is further exception to what three exceptions we have seen in the membership. So the government has the power. Now section 22 subsection 1 also there is some power given to the government, we have seen later, and one more further things are also given. Being admitted or continuing to the member shall be eligible for a membership only to the limited extent of specified society, or so long as such person or persons are engaged in or carrying out that business or employment as the case may be. And the question whether a person is or not so engaged or carrying out. Now question comes. Now there is a special order that the person who is the trader in a fertilizer cannot become a member in a marketing society, is the general order. Now whether there is a conflict or not, who will decide? Who will decide? The general order is done. Based on that, a particular member may not be admitted as a member of the society by a who? By a society. Suppose I am doing trading in the fertilizer. Now I want to become a member in that marketing, so who is also trading in a fertilizer. Now I apply to that society to become a member. Then that marketing society can refuse my membership, saying that you are already a trader. Why I am refusing? Because your business is conflicting with me, and he has to give reason and rejects. Once he rejects, then the clash arises, and because this clash has arisen, now who will decide about the membership? The conflict will be carried out. Question whether a person is not so engaged or carrying or any profession, business or employment, whether a person belongs to, does not belong to such class of person declared subsection and shall has not been incurred a disqualification under this subsection shall be decided by the registrar under section 11. Now one more, I am just giving in a perspective of a housing society. Now we know that builders, who is a builder, correct? If he is a builder, what he does, in order to get a redevelopment proposal in his name, there is one or two builders in Mumbai. What they do, they buy one or two flats in a particular housing society which is going for redevelopment or which is in the workshop redevelopment. Why they do? So that they are acquaintance with the committee, they are acquainted with the member, and they are able to pitch their proposal to get redevelopment. In such cases, if such membership come, whether the managing committee can reject the membership saying that you are a builder, you are carrying out, our society is looking for redevelopment, therefore we will not admit you as a member of the society. Okay. Now this has happened, which Sanghar, she is now handling one matter. We will have to see how that gets further. In the case of a MADA society here on DN Nagar, where a builder has purchased a flat from the outgoing member, and actually that builder should have been admitted as a member, he did not apply for the membership, later on he sold that to another person, okay, one Mr. Ashok Bajaj. It has been sold to Mr. Ashok Bajaj. Now we have applied for the membership. Now the society says, because it was purchased by the builder and we do not recognize that flat as the flat belonging to outgoing member, whereas if this was not a builder, then this would have been a separate situation. Now that it was purchased by the builder and that builder we have terminated, that was the right acquired by him also gets terminated. So this is a stand taken by the society. Suppose we want to take that stand, maybe one can look into that. But right now I am saying it is a government who can decide, and once they pass a general or special order, then of course it will be decided by the registrar under section 11. What is section 11? Let us look at, because section 11 is prior to section, so let me, because there is a reference of section 11, let us look at section 11. That will give you some idea. So section 11 is about the who can be admitted as a member. The question of membership will be decided. That is, of course, it is more related to agricultural society. Let us look at this. Section 11, power of the registrar to decide certain questions. When any question arises, whether a person is an agriculturalist or not, or a person, as we have seen under section 22(1)(a), that is there any conflict of interest? One, this was related to agriculturalist. So people sometimes in rural area, whether he is an agriculturalist or not an agriculturalist, because he wants to become a member of an agricultural society. By becoming agricultural society, he gets the benefit of seeds at a lower price, certain grains at a lower price, he gets subsidized loan, all this. So therefore, when any question arises whether a person is an agriculturalist or not, because he can become member of an agricultural society. If he is not an agriculture, then he cannot become member of agricultural society, because then it does not become a voluntary or for pursuing certain profession or a business. So when any question arises whether a person is agricultural or not, whether any person resides in the area of operation. Now, what is area of operation? That is also equally important. Now, a society is registered for a particular area of operation. The bylaw also provides the area of operation. So, suppose I am an agriculturist and I am residing in a particular village, then I can become a member of that particular society which is in that village. If I am staying in a village, there is a society, agriculture society in a village, naturally I can become member there. But I am staying in A area, but there is a B area also where there is another society. Can A area member can go and become member of B area? The answer is no. Is it clear? So therefore, the question arises whether he is staying in that area or not. How they will look into? They will go to Aadhaar card or PAN card or residence proof or ration card, whatever. So when a question arises whether a person is agricultural or not, whether a person resides in the area of operation of the soil or not, or whether a person is not engaged in carrying on a profession, there is a conflict of interest, or a business or employment, or whether a person belongs or does not belong to a class of persons. Again, a class of person. Let us say there is a society which is catering to the backward class. Okay. Because if backward class people, scheduled caste and scheduled tribe people come and form a society for pursuing their own business for their own benefit, the entire income is exempted from income tax under the Income Tax Act. So no income will be liable for income tax, because that is concerning to the scheduled caste and scheduled tribe. If that is the case, whether that person is belonging to that class of the benefit, for example, as we have seen, there is a reserve category for scheduled caste, scheduled tribe. So same way, whether a person belongs or does not belong to that class as declared under subsection 1A, again 1A we have seen, and as or not incurred a disqualification under that subsection, such questions shall be decided by the registrar and his decision shall be final, but no decision adverse to any such person shall be given without giving an opportunity being heard. That means before declaring that person is not entitled to become member, that means he has to be given opportunity. Law of natural justice, an opportunity has to be given. So I think section 11 is clear. That means power of the registrar. Now that is a power of the government. Section 22 also there is a power of the government, and section 22(1) also there is a power. Section 22(1)(a) also there is a power. Okay. Now let us get to the PPT. Even housing society right now it is not applicable. There is no such government order which has been passed. Yeah. Right now it is not. Right now, who cannot become a member in a housing society has not been given, except yes, again under section 22 only, as I said, there is a special order issued by the Maharashtra government as far as housing society is concerned, that in a housing society more than 50% members should not be from a corporate body. So if the membership, let us say there are 11 members in a society, already 5 are admitted as a corporate, 5 are individuals, then 6th one is purchasing that, then he can be rejected membership under section 22(1)(a), and thereafter whether he is corporate body or not a corporate body, or by the registrar. Of course section 22 is also registrar who will decide. Read with section 11, because 11 is giving him a power, section 22 also giving him a power. ठीक है ना, both are concurrent power. One can go under section 11 or one can go under section 22. Section 11 he can go in advance also. I am so and so class, I want to apply, so give me a certificate that I can become member or not to become member. Here he has rejected, thereafter one can go ahead with that, because if that reason is given that he is having a conflict of interest, and therefore then register we can go. So they are concurrent provisions. Okay. See, there are certain provisions in the act which are concurrent. Of course I have to specifically say, but I can always say the registrar can use the power under section 22(1)(a) read with section 11, because here also it is saying like that only. If you read, just go back, if you see here, decided that any person engaged in or carrying out business under this subsection shall be decided by the registrar under section 11. 22(1)(a) read with section 11. Power is under section 22(1)(a) read with section 11. Tick. Now 1B, that means another thing also has been added. Notwithstanding anything contained in subsection 1 of section 22, where the registrar has decided under section 11 that a person has incurred a disqualification under subsection 1A. Now the registrar says, yes, you are disqualified, because in a housing society more than 50 cannot be body corporate. Now you have become a body corporate, so I am now disqualifying under section 1. The registrar of the person not below the rank of district deputy registrar of the cooperative society authorized by him in this behalf may or by order remove such person from the membership of the society. Now, who is the person who decides whether he is entitled to become a member or not to become member? Registrar. Registrar means the person who has registered the society. Now, who can remove him from the membership? Not below the rank of district deputy registrar. So there is a registrar, the last time we have said, there is a district deputy registrar, there is a joint registrar, there is an additional registrar, then there is a registrar of cooperative society which is a commissioner. So the registrar or the person not below the rank. Now here is the registrar. Of course the registrar means again same deputy registrar, or the person not below the rank of district deputy registrar of a cooperative society authorized by him. Okay, authorized by him. So that means the registrar or the district deputy registrar can authorize an advocate or XYZ person, okay, authorized by him, may or by order remove such person from the membership of the society. So he can be removed from the membership of the society by getting into the society's premises, taking seize of the documents like share certificate or share register, I form, J form, all the register, may by order or remove such person membership of the society, and such person shall cease to be the member of the society on an expiration of a period of 1 month from the date of receipt of such order by him. That means he will cease to be the member of the society after this order. Okay? Then subsection 2. Now till this subsection 1, we have just discussed subsection 1, subsection 1a, subsection 1b. So do you have any questions on this? If you look at it, subsection 22, section 22, subsection 1 talks about conditions for membership. Then certain provisions are given who can become member. Section 22, subsection 1a talks about the order of the government where there is a conflict of interest because of which certain person will not be admitted as a member of the society, and again whether he is qualified to become a member of the society or not will be decided by the registrar under section 11. 22 1b says that removal of such member, once he is disqualified under section 11, how he can be removed? By the registrar or by the district deputy, not below the rank of district deputy, or by any person authorized by them. So, and such member, once the order is passed that they are removed, then they cease to be the member of the society due to the conflict of interest or for any reasons. Then from the date of passing the order, within 1 month they cease to be the member. Any questions so far? Now subsection 2, where a person is refused admission as a member. We have earlier seen a membership, there can be approval, there can be rejection, and there can be withholding. Okay, now the question has come, refused. See, when we are applying for a membership, appeal, that is appeal before the deputy registrar, because application is with the society, appeal. Once we are making appeal, we have to understand under which section we are making an appeal. So if there is a refusal and there is an letter by the society, we have not admitted you as a member because you are belonging to scheduled caste or you are belonging to Muslim community, you are because you do not have this document, that document, there are certain reasons, or you are not from the Sangli area. Because ours is a Sangli Vaibhav Co-operative Society. Only people who are staying in Sangli only will be able to admit as a member. So they may say that you are not from Sangli. So therefore you are not from Kannadiga. You are not, because ours is a Kannada. There are some societies which is a GSB oriented, then the community oriented, Aga Khan community, this community, that community, Parsi community. Because you are not belonging to our community, so they may refuse your membership. So if they are giving a reason and refusing, then section 22 subsection 2 comes, where a person is refused admission as a member next of a society, the decisions with the reasons thereof, that means the decision with the reasons thereof shall be communicated to that person within 15 days of the date of the decision. Who has to decide? Who has to communicate? Committee. Because the application is made to the society, that means society has refused the membership, and because they have refused the membership, with the reasons thereof shall be communicated to that person. That means that person means the person who has applied for the membership. Within 15 days of the date of the decision, suppose a managing committee has decided to refuse his membership, then within 15 days he should be communicated, or within 3 months. You have decided, let us say a membership was given, for example membership was given on 1st of January 2022, and you have decided, because there was a general managing committee meeting on 2nd of January 2022. Now you have decided in the 2nd January meeting that membership should be refused. Okay. Now you have to communicate this is within 15 days. 15 days means let us add 15. That means by 17th of January you have to communicate because decided on 2nd of January. Are you with me?
Yes.
Now you are issued the membership on 1st January 2022, but you have decided, let us assume, to reject him on 31st of March 2022, which is within 3 months. That means you have to communicate to them by 15th of April 2022. Are you with me? So the day you decide, there may be so many managing committee meeting held in between, but you have not decided about his membership. So the day you decide about the membership to refuse, in that case you have to communicate the decision within 15 days of such decision which is passed in the managing committee or in the general body as the case may be, because sometimes the membership, whether to grant membership or not to grant the membership, they take it to the general body. So it can be a special general body, it can be annual general body meeting. So wherever you decide, so naturally that is where it is. Within 3 months from the date of receipt of the application, that means for admission. Even if you want to refuse, okay, you can still within 3 months of the date of receipt you have to refuse, whichever is earlier. So here I was saying 15th April, that is wrong now. Okay, so that means it has to be before 31st March. Suppose if he is decided, he should communicate by 31st March only, whichever is earlier. So maximum period is 3 months. So by 31st March, so 15th April, what I said is wrong. Now, if the society does not communicate any decision to the applicant, now the question arises, if they do not communicate. If the society does not communicate any decision to the applicant within 3 months from the date of receipt of such application, the applicant shall be deemed to have been admitted as a member of the society. Deemed means legal fiction. It is not actually admitted. But the law says within 3 months you are not decided, so you are deemed a member. Further it is added, if any question arises whether a person has become a deemed member or otherwise, the same shall be decided by the registrar after giving a reasonable opportunity of being heard to all the concerned parties. That means a question now arises whether he has become a deemed member or not. Correct? Who will decide? The registrar will decide. That means we have to file an appeal before the registrar. 22(2). If he has been refused membership, I will come to that. So 22(2)(1), he has been refused membership or no decision is taken within 3 months. He is deemed member, and because he has become a deemed member, now I can file an appeal before the deputy registrar or the assistant registrar. This is clear now. We will go to 123, 1A later on. So till now it is clear. So if a membership is refused, you go for appeal. If it is not refused but he is holding it, no decisions are passed within 3 months, he is deemed to be the member, and because he is deemed to be the member, you file an application under section 22(2) to the deputy registrar. Now, no society shall without sufficient cause refuse admission to the membership to any person duly qualified thereof under provisions of this act, and it is by law. So now comes section 23. Section 23 talks about open membership. What do you mean by open membership? Open membership means no person shall without sufficient cause. So nobody can be refused membership. Everybody, irrespective of caste, region, religion, community, whatever it is, irrespective of anything, he should be, no society shall without sufficient reason. पहला क्या बोला सेक्शन 22 में, नो पर्सन शैल बी एडमिटेड एज ए मेंबर ऑफ द सोसाइटी सब्जेक्ट टू सेक्शन 24 एंड देन प्रोविजो वगैरह दिया, इंडिविजुअल दिस. नाउ दे आर सेइंग नो सोसाइटी. नाउ इट इज अप टू द सोसाइटी. नो सोसाइटी शैल without sufficient cause refuse admission to the membership to any person duly qualified, therefore under the provision of this act or bylaws. Now, when we are making an application for deemed member, we write section 22. section 20, section 22, section subsection 2. We also refer to section 22. Why? Because he is competent to contract. So we say that he is a competent to contract. So therefore under section 22(1) he is qualified to become a member. Section 22(2) within 3 months he was supposed to give a decision which he has not given. So I am becoming a deemed member. So that means both the sections I am referring. Now under section 23(1) also I refer. Why? Because the society cannot refuse me. Now the society has refused. So I refer this section also, saying that because these are all, as I said, they are all concurrent sections. So therefore it is, you know, if you have seen the writ petition, sometimes we write 226, sometimes we write 227, and majority times we write 226 and 227. We will read that Constitution's article 226 and 227, which more like, you know, overlapping. So here is the situation where the sections are overlapping. So we should be, when we are making an appeal petition, we should say that he is competent to contract, he is not disqualified, or he is entitled to become member under section 22(1). वो लिखना चाहिए. He is fulfilling conditions which are cast, and he is also fulfilling the open membership criteria where the society has now refused under section 22(2), because he has refused, but the cause which he has given is not sufficient, or he has not given anything, there is no sufficient cause to hold the membership. Are you getting my point? So section 23(1) भी बोलना पड़ेगा, because here society has refused. Refused, the cause which he has given is not sufficient or is not as per the legally tenable. ठीक है? Are you with me? They are holding it also for no reason or rhyme. So that also you can say. So इसको subsection को आपको बराबर हर petition में, हर pleading में we need to explain that. Now what when we are doing an appeal, we don't write that pleading that explicitly. We simply write he has to be made a member, he is deemed a member under section 22, read with section 23(1)(a, ऐसा करके छोड़ देते. But now that we are understanding how the pleading should be done, pleading has to be done with reference to certain sections of the act, and that sections has to be properly referred, and then you have to give your explanation to that section. The applicant is the entitled or competent under section 22 subsection 1 to become a member of the society. There is no bar. Secondly, section 23(1) also, the society which has given refused membership has not provided a sufficient reason, and that sufficient cause is not within the provisions of the act. The reasons given are so and so, they are beyond the provisions of the act. Then because within 3 months they have not given, so therefore under section 22 subsection 2 he is deemed to be the member, and therefore the membership will be granted, because it is you who has the jurisdiction. Because we have to also, as I said in the last lecture, first and foremost we have to establish that the particular registrar or the before whom we have filed the case has a judicial power, or he has a jurisdiction, and that also can be given. Section 22 also says it will be decided by the registrar, and therefore you have the jurisdiction and power. So this pleading has to come clearly. Now one more thing has been added. Now this is where you are getting confused, if at all. But there is no reason for getting confused. But if you are getting confused, let me write it here and explain it. Section 23(1)(a) has been added. Where a society refuses to accept the application, try to understand the difference between refusal of the application and accepting the application. Are you with me? Now we are facing one situation in Andheri East, or many times it happens, even in the case of Ashok Bajaj, there also the society was not accepting the application. Then we sent by post, then he refused the membership. So even if you send it by post, still they don't accept. So here is a situation, where a society refuses to accept the application. It is not the refusal of the membership. अभी समझ में आया? So, where a society refuses to accept the application from an eligible person for admission as a member or payment made by him in respect of the membership, like share money, entrance fee or transfer fee, such person may tender an application in such form as may be prescribed. Now, the moment the word prescribed comes in the law, means what? Prescribed means prescribed in the rules. The moment the word prescribed comes in the act, just underline it and go to the rules. In such form as may be prescribed. कई बार एक्ट पढ़ते हैं तो prescribed किधर है ढूंढने की जरूरत नहीं. Prescribed means go to the rules. Rules referring to that section, there will be a rule, and in that rule there will be form. Now, where a society refuses to accept the application from an eligible person for admission as a member or payment made by him in respect of a member, such person may tender an application in such form as may be prescribed together with the payment in respect of membership, if any, to the registrar. Now, which is the form? That is H1 form. ठीक है? Mr. Santosh Giri is facing a challenge because K Eastward Shanti apartment, that registrar is not accepting even the application and forwarding to the society. Anyhow, but we have submitted. Now, where a society refuses to accept the application from an eligible person for admission as a member or the payment made by him in respect of members, such person may tender an application in such form as may be prescribed together with the payment in respect of the membership, if any, to the registrar, who shall forward the application and the amount, if any, so paid to the society concerned within 30 days from the date of receipt thereof. That means within 30 days from the date you have made an application to the registrar. Now, H1 form you have given to the registrar, he has to submit within 30 days, forward it. If he is not forwarding, that is his funeral. You can give one more reminder. Tomorrow itself you write one more reminder on the letterhead of One Stop Legal Solution, that on so and so date accept the copy that we have given such and such application, and under section 23(1)(a), it is your duty to forward it within 30 days, which you have not forwarded. ठीक है? And you can also put an RTI, the action taken report. Put an RTI, that is better. हाँ, give us the action taken report under section 23(1)(a). You were supposed to forward it to this one. So right now we have not received any communication. Give us a status report, action taken report. ठीक है? So that RTI can be done. One reminder also can be done. Both the things you do. Okay? Now, where a person refuses to application, now here is the question, refusing to accept the application itself. There, refusal to the admission of member. This is the difference. And here is the situation where the registrar is duty bound to forward it within 30 days when we are submitting in H1 form. Application and amount, and thereupon if the society fails to communicate any decision to the applicant within 60 days from the date of receipt of such application. Now, who forwards it? Registrar. And after the registrar forwards it within 60 days, earlier it was 90 days. No, registrar has to forward it within 30 days. Thereafter the society gets 60 days. In the case of section 22, subsection 2, there was a period of 3 months, maybe approximately 90 days. Correct? Yes. Here is the case. Within 60 days from the date of receipt of such application and the amount by the society, the applicant shall be deemed to have become a member of society. Here is another situation. We are giving a membership to the registrar, and the registrar communicates it to the society within 30 days and whatever the dates, and from there 60 days, if the society does not accept or grant the membership, then the applicant shall be deemed to have become a member of the society. If any question arises, what is written in section 22 is same. If any question arises, whether a person has become a deemed member or otherwise, the same shall be decided by the registrar after giving a reasonable opportunity of being heard to all the concerned parties. I think now things are more clear. We may do simultaneously. we submit to the society, we are waiting and we are not getting, we are sending it to the registrar. In that case, we can say we have exercised this power, still it is not there. Section 22 1A, 23 1A also we have done, we have given to the registrar. Within there also we have expired 60 days. In both the cases, he has become the, under both the provisions of the section, he has become the deemed member. So, any person aggrieved by the decision of the society. Now any person, that is 23(2). Again the same things we are talking about. Here registrar has sent, okay, 22(2) where the membership is refused. Now 23(2) में भी वही बोलता है. Any person aggrieved by the decision of the society refusing him as a member may appeal to the registrar. Now the question is 23(2) में अपील का बारे में बात की है, बराबर है. गो टू सेक्शन 22(2). उधर अपील के बारे में बात ही नहीं की है. सो अपील टू द रजिस्टर इज अंडर सेक्शन 23(2) ओनली. डीम्ड मेंबर इज आइदर 22(2) और समझ में आ रहा है 23(1A). नाउ our appeal is always under section 23(2). Membership appeal is always under section 23(2) and deemed member can be read, deemed member can be under section 22(2) or 23(1A). 1A, when the application was refused, we have gone through the registrar. Or 22(2) is when the application is given to the society, they have not taken within the 3 months. So the appeal is always under section 23(2). Whether he is a deemed member or not will be decided under section 22(2) or 23(1A). But appeal has to be filed under section 23(2).
So 22(2) and 23(1A is simple application made to the
22(2) is an application made to the society where they have not decided within 3 months.
Yes.
So therefore it is a deemed member.
Yes.
If you are deciding that you are a deemed member,
Yes.
you have to file that appeal, na?
You have to file the appeal.
You have to file appeal section 23(2). The appeal is under section 23(2).
It is the only sort.
That is where he gets the power. And once you file an appeal saying that they have not decided on the application, or they have refused the application. These are the two situations.
Right.
Okay. If they have not taken a decision, then you have to say 23(2) read with section 22(2) or section 23(2) read with section 23(1A) or section 23(2) read with both. I have applied to the society, they have not taken within 3 months. I have applied to the registrar also, still they have not taken a decision. In both the situation, he is a deemed member. Correct, Mr. Miranda, na? Okay. Now is it clear?
Yes.
Appeal is always under section 23(2). You say read the section 22(2). It doesn't say appeal. It says the registrar will decide a question whether he is a deemed member or not. When he will decide deemed member or not? When the appeal is filed. 23(1A) also he decides whether he is a deemed member or not. When he will decide whether he is a deemed member or not? When application is refused and registrar has sent. So there are two situations. Okay? Appeal is under section 23(2). And 23(1) also we say. Why? Because he has refused for no reason or withholding no reason. 22(1) भी हम रेफर करते हैं. All this you can refer. Section 22(1) provides that he should be. So he is qualifying under section 22(1). 23(1) they have given these reasons which are not legitimate reason. They are not sufficient cause, which is not as per the law. ऐसा करके आपको pleadings जो है ना अच्छे तरह से अपन membership का कर पाएंगे and करना चाहिए. ठीक है. Now 23(1)(b). What is that? Again further exception. Now 2. Any person aggrieved by the decision of the society refusing to admit his membership may appeal to the registrar. Every such appeal as far as possible be disposed of the registry within a period of 3 months from the date of its receipt. The registrar को भी time from दिया है. Now the question arises, if he does not decide within 3 months, what happens? He has to decide within a period of 3 months. Now it says, provided that where such appeal is not so disposed of within such period of 3 months, the registrar shall record the reasons for the delay. That means रोजनामा में next date मांगा, reply मांगा, ये मांगा, वो मांगा, but positively he should do within 3 months. Now there is something called a mandatory. A timeline is given. The timeline is called, one is mandatory, the another is called directive. Can somebody light or give some feedback on what is mandatory and what is directive? बोल सकते हैं? What is mandatory and what is directive? So something is mandatory, बराबर ना? Mandatory. Third is directive. So when it is a directive is something which is expected. It's something like a direction, guideline, or expected that within 60 days the complaint should be disposed of. It's expected, and otherwise you give the reasons. Same way in the appellate tribunal RERA also it says within 60 days it should be disposed of. So the High Court and Supreme Court has said such provisions are directive. Now within 3 months the society has to decide, that is mandatory. Within 3 months, section 22(2) or section 23(1)(a), they are mandatory, because these are the statutory period laid down. Let us say 30th September you have to have the general body. That means that is mandatory. Okay. Now one more thing which you can always look at, what is mandatory and what is directive, is if there is a consequences prescribed on failure of the deadline, then that can be considered as mandatory. And if there is a directive, then a liberty is given to the deciding authority to record the reasons. Whereas society, such reasons they cannot record and extend the period of 3 months of either granting or refusing the membership. The consequence is mentioned. So whenever we read the law, we need to, as a student of law, we need to check whether it is a mandatory, prescribed is a mandatory, or whether it is a directive. If it is a mandatory, now rule 9 of the MOFA rules, it says that within 4 months from the date of formation of the society, that means it is a mandatory. Okay. There is no other reasons by which he can extend. So what is important is we have to look at whether it is mandatory or directive. Here is the situation where it is a directive. The decision of the registrar in appeal shall be final. Now the word used is final. Now the moment the word final comes, that means there is no appeal. The decision of the registrar in appeal, because this is appeal, this itself is a appeal. So that means application is made to the society. So appeal is always with the registrar. So the decision of the registrar in appeal shall be final, and the registrar shall communicate his decision to the parties within 15 days from the date thereof. That means once he decides, within there 15 days he has to communicate. Next. Now again, honestly speaking, that 15 days can be considered as again a directive, because there are so many close for order and 3 months 6 months होता है, फिर भी order हाथ में मिलता नहीं. So anyhow, now section 23(4), without prejudice to the foregoing provisions of this section. Now without prejudice. Now it is again exception or negative covenant. Without prejudice. Without prejudice means without getting into the merits or demerits of the things, without referring to those, without prejudice to the foregoing provision of this section. In the case of an agro-processing society or any other for which a definite zone or area of operation is allotted by the state government or the registrar, it shall be obligatory on the part of such society to admit on application made to it every eligible person from that zone or the area of operation, as the case may be, as a member of such society, unless such person is already registered as a member of such any other such society into the same zone or the area of operation. That means without prejudice to what has been stated, the right of refusal, this section says in the case of agro processing societies, okay, the person who is admitting or applying, he should be made as a member of the society. Now we are not much concerned with the agro here. Now section 24. Because section 22 says subject to the provisions made in section 24. Now what is section 24? Notwithstanding anything contained in section 22, a society may admit any person as a nominal or associate member. That means one is a membership is there, then there is a nominal member as well as associate member. In a case of a housing society, nominal member is now done away with. Now there is only joint member, provisional member and associate member. However, section 24 is not applicable to housing society. Since we are referring to section 22, therefore let us refer it. A nominal member shall not be, again section 22, 23 is also not applicable to housing society.
Yes, 154.
So the housing chapter membership entire thing has been replaced. What are the rights of the member and all, but still we are referring to them. Notwithstanding anything contained in section 22, a society may admit any person as nominal or associate member. A nominal member shall not be entitled to any share in any form whatsoever in the profits or assets of the society as such. So the rights of the nominal members are given. A nominal member shall be ordinarily not have any of the privileges and rights of the member, but such a member or associate member may, subject to the provisions of section 8 of subsection 8 of section 27. Section 27 is rights of the member, voting rights of the member, have such privileges and rights and shall be subject to such liabilities of a member as may be specified in the bylaws of the society. Nominal member का अधिकार क्या है, that has been given. Next, section 24A is regarding the education and training. Every society organizes cooperative education and training to its members, officers, employees through such state, federal societies or the state apex training institute as the state government may by notification in the official gazette specify. Such education and training shall ensure the effective and active participation of the members of the managing committee. Education and groom talented employees for leadership position. Develop professional skills through cooperative education and training. Every member of the society shall, whether elected or co-opted, shall undergo such cooperative education and training for such period and such interval as may be prescribed. As may be prescribed. That means in the rules it will be there for housing society. Every society will contribute annually towards the education and training of the state, federal society or state apex training institute notified under subsection 1A. Who notifies? Naturally the government, because that power is with the government. At such rates as may be prescribed and as such rates as may be prescribed by the notification here, because notified under subsection such rates as may be again prescribed either in the rules or by the notification, and different rates may be prescribed for different society or class of societies. Cessation of membership. Now when a person becomes ceased to be the member, there is a difference between removal of a member, cessation of a member and expulsion of a member, which we will discuss in the next class. There is a cessation of a member, there is a removal of a member, there is a expulsion of a member. Okay? So today any questions so far whatever we have discussed?
Samsayik society, it has been formed with an objective to only admit Zoroastrians. There is a case law in the
correct
side also. So if a non-Zoroastrian applies to the society, so by that taking the
Supreme Court judgment,
taking that judgment into effect, why it was refused, the decision of the society? If the objective is just to admit Zoroastrians, and if a non-Zoroastrian has already applied, then why the grant of membership to that non-Zoroastrian?
Now this Zoroastrian, there is a case law, Zoroastrian cooperative housing societies. It is in Gujarat. Now the way section 23 we have open membership, no society shall refuse the membership without sufficient cause. This section which is there in the Maharashtra Co.Op Society Act is not there in the Gujarat Cooperative Societies Act, because the cooperative society is always governed by the respective state. It's a state subject. Cooperative is a state subject, and therefore, now how is the state subject? Schedule 7 of the constitution and all, that is a later part we will discuss. But right now let us understand the every state has the authority to enact their own law. And these Zoroastrian cooperative societies where they had refused non-Zoroastrian, that is Parsis, as a member, the matter went up to the Honorable Supreme Court, and the Honorable Supreme Court said, yes, when the society was categorized and made under a specific act and for a particular community which was permitted under the law, and therefore they are granted, the membership refused was accepted by the Honorable Supreme Court. Whereas similar situation had arisen in Maharashtra. There is one, either Solset, or Solset is a Christian community at Bandra, or there is one Talmakiwadi. You just go and Google Talmakiwadi Cooperating Society. So in the case of a Talmakiwadi Cooperating Society at Girgaon, there the bylaws provided that only Hindu GSB, Gauda Saraswat Brahmin, okay, who is from that particular community will be admitted as a member of the society, and it was accepted in the bylaws registered under the Bombay Cooperative Society Act 1925. So it was registered. But when it was a non-GSB person purchased the flat and he had applied for the membership, then they referred the bylaws saying that this bylaws has been registered by the same registrar and approved, and therefore under this bylaws we are not admitting a non-GSB as a member of the society. And then the registrar directed under section 14 of the MCA's Act to amend the bylaws, saying that this bylaws, though it was accepted at that time, now it is against the directive principles or the provisions of the section 23 of the Act, and you cannot make such provisions in your bylaws. The matter went before the Honorable High Court, and the Honorable High Court said, yes, it is an open membership. This type of restrictive clauses cannot be there in the membership clause for any society, housing society, and accordingly the matter has now settled as far as Maharashtra is concerned that it is open for everybody. Okay. Now, there can be situation. I am not saying that there cannot be a situation. Let us assume a situation which I am referring specially. Now, government gives a land to all the members, 100% of the members should be for scheduled caste and scheduled tribe. And governments grants that land, and this housing society is also found for that particular community. Okay. Now, whether a non-scheduled caste can purchase and can become a member of the society. If the land has been granted only for the welfare of a certain community through the social justice department at certain concessions and certain provisions, then that will have to be upheld and prevailed, and if that has to be done, there has to be special permission from the government, then only it can be done. So these are the things which again, as I said, everybody is admitted as a member of the society. Now as I said, if this particular society is made on a particular community based, yes, as I said, it is only for scheduled caste and scheduled tribe. Then a non-scheduled caste want to become member of that society. Let us say credit society, I am just giving example. Credit society is only for the scheduled caste and scheduled tribe, and because we are going to get the benefit of that, so whether a membership can be refused to the non-scheduled caste, according to me, yes, you can, because if you admit anybody else, then you lose the benefit which is granted under the income tax. Income tax says if it is for a particular community based, then you lose. So based on that you have done, or government grants the land based on certain things. So there is some called economically weaker sections, these, that. So these are the debatable point. I do agree. There are concurrent provisions, there are concurrent measures. So I can also go with one more step, saying that now solicit, or there is one society at Borvili, sorry, the Isar. Now this is promoted by our community. Okay. Now what has happened, that particular land was given on lease basis, 99 years lease, by Swamiji, saying that this land has to be used only for affordable housing to our community people. Now that is a condition, put it in the lease, and nobody else can be given the house in that. Now that means now the housing society is formed. Of course, membership has to be given. Now what will happen to the flat ownership? This is again a question mark. That means lease has to be challenged. You have accepted at that time where the lease was given, because it is owned by me, the land is owned by me. I am the person who will decide. Again, the moment you convert into housing society, the characteristics changes. If you had not done, now this type of dispute also has arisen in the case of army welfare. Now army welfare, okay, the army people come together, they have a army housing welfare association. Now they buy the land from the government or other authorities, and for the purpose of army, they form a, again AOP. They don't form a housing society, at least in Maharashtra, because they know that if I form a housing society, then I get into the clutches of a cooperative society, and then non-army people also they can sell, and the very purpose gets defeated. However, the law also provides for under non-cooperation. So we have done a society under the non-cooperation of army housing welfare, CIDCO's condition, everything was saying that it will be done only under the AOP, that is Associate Person Under Society Registration Act. We said nothing doing. They also put a condition that if you form a association under the Society Registration Act, there was a corpus pending with them about crores of rupees. They said we will give only when you do. I told the society, let us do association of persons. We took the corpus, and thereafter we converted into housing society. So this type of things do happen. So anyhow, these are the matters where the discussion, debate, and people like you and I will have to intervene, understand, and tell them that we have to go to the root of the matter and understand this is the land which was given by the MHADA only to this class of people and under certain conditions, and based on that for the management housing society has been made. So membership can be granted to a housing society only he is entitled to acquire the right in the property. If he is not entitled to acquire the right in the property and the per se, that itself is illegal, then we have to challenge that contract itself. Then one more civil proceedings, all these things starts happening, and that is how one has to look into it. Apply your mind, apply your intelligence, apply various other provisions of the law. So thank you very much.